Hi, I'm lawyer Jessica Bornick, and welcome to Legal Juice, a vlog of legal information, education, and entertainment. Today I'm going to talk to you about the factors you should consider when deciding who to name as your executor. First things first, a disclaimer. Although I am a lawyer, I am not your lawyer. Should you require legal advice, please seek the assistance of a lawyer licensed to practice where you are. Do not rely on anything you see in this video as legal advice, and do not delay in seeking legal advice based on anything you've heard in this video. And now, if you like this video and you want to see more content like this, please be sure to like, share, and subscribe. Now join me as we talk about picking an executor for your will. Before we get into the factors, we just need to briefly touch on what an executor is and what their job entails. Your executor is the person or persons you name in your will to carry out your wishes. They step into your shoes upon your death and deal with your assets and liabilities. The appointment of an executor can be confirmed by the courts if you were to get a grant of probate. You may hear various terms thrown around that are synonymous with the term executor, such as executrix, trustee, and personal representative. Where I am now, we use the term personal representative, but for the sake of understanding, I will refer to this person as the executor in this video. An executor has many, sometimes countless duties. They must collect, insure, and secure the assets of your estate, advertise for creditors and claimants, make income tax elections, pay all the legally enforceable debts before distributing your assets to the beneficiaries. They need to locate and report to the beneficiaries. They need to be a mediator between beneficiaries who don't get along. They will represent your estate in any litigation, and litigation is time-consuming, expensive, and onerous. An executor could be tied up in litigation for years, if not decades, and find themselves on the hook for hundreds of thousands of dollars of legal fees that they must pay out of pocket. They will need to close all of your accounts, including online and social media accounts, wind down and sell any business interests that you own. They may even need to run your business for you for a short period of time before they can close it down. Long story short here, an executor has many duties. If you want to know more about these duties, I offer a free executor checklist on my website, and I will put the link below for that in the description of this video. Now, we know what an executor is and what he or she must do. Let's talk about the characteristics of the person or persons you want to appoint as your executor. First, the law sets out some minimum requirements. Your executor must be an adult, and they have to be of sound mind. Number two, your executor can also be a beneficiary. I should note here that any compensation an executor takes will be taxable in their hands as income. Inheritances, however, are tax-free, at least here in Canada. So it is likely if your executor is also a beneficiary that they will take no fees as compensation for the duties they are carrying out on your behalf. Number three, your executor should be someone who is able to handle the job and also deal with your passing. If they can't handle grief, do not pick them. I have seen instances where the executor has so much trouble dealing with their grief that they do absolutely nothing for months or even a year. This is a big no-no and will open the executor up to personal liability. If they fail to deal with the assets in a timely manner with the best interests of the beneficiaries of the estate in mind, they could miss important tax filings, resulting in penalties and interest that technically they will be personally liable for because those could have been avoided had they acted in a timely manner. Similarly, property and assets can get lost, stolen, or degrade when neglected by the executor, also rendering the executor personally liable for any of those types of losses sustained. The next factor is age. Now, I sometimes get clients that tell me they have no choice but to appoint a distant relative like a niece or nephew because that person is the only relative that they have that is younger than them. Age, although a factor, should not be your only consideration. You appoint the person you think would be the best to get the job done, and that might be an older relative or friend. You always appoint an alternate. And because this is an onerous job, always, always, always ask your executor if they are willing to act before you name them in your will. Never voice this job on anyone, and never keep your estate plan and wishes secret from your executor. Number 5, another important factor to consider is trustworthiness. You need to ensure that the person or persons you appoint as your executor are trustworthy. Your executor is what is called a fiduciary. They have a fiduciary duty to your beneficiaries to act in their best interests. Your executor is required to report to your beneficiaries, and it is the beneficiaries that police the actions of your executor. However, if your executor does not tell the beneficiaries that they are the beneficiaries of the estate, then there's essentially no one watching the actions of the executor. And the executor could drain the estate and be in Belize before you know it. And Belize is a country that speaks English and has no extradition treaty with Canada. Number 6, skills and ability. Now, depending on your assets, it can take your executor anywhere from a year to decades to wind down your estate, especially if you have complex assets or trusts established in your will. You need to make sure that the person you appoint is meticulous and can handle potentially vast amounts of money in a responsible and informed way. Number 7, you want to appoint somebody that knows you. One of the first tasks your executor is liable to perform is to make funeral arrangements for you and handle the final disposition of your physical body. I oftentimes get clients ask me if they can appoint me to act as their executor. There are a number of issues with that. First, I won't be able to help you with your estate planning because I will be in a conflict of interest if I draft your will that names me as your executor. Second, I won't be able to represent your estate from a legal standpoint because I will be your executor, so I will have to retain outside counsel to assist me with any legal matters. Third, I am required by law to report to the Law Society all of the details of any trusts for which I am trustee outside of the scope of my legal practice. This essentially means that your information could become public knowledge with the Law Society and their representatives. Number 8, perhaps one of the biggest factors people don't even think about is the residency of the executor. Now, if you appoint somebody who resides outside of your jurisdiction, for instance, if you're an Albertan and you appoint your son, say, in Ontario to be your executor, the court here will require that your son post what is called a performance bond, which is 2 times the aggregate value of your estate, and it cannot be posted from estate funds. It must be posted from your son's own funds or insurance that he obtains. Now, what is a performance bond? Well, a performance bond is basically insurance that the court holds on to ensure that your executor will not flee the jurisdiction with the estate funds and dupe the beneficiaries out of their inheritance. There is a way, however, to get around the requirement to post a performance bond. You can appoint a joint executor resident where you are to act with your foreign executor, but you will also need to include a clause in your will that clearly lays out that you have the utmost confidence in your executor and that you wish that they be appointed without the need for the performance bond. Additionally, if you are the sole, meaning the only beneficiary of the estate, and you are the foreign executor, you can say to the court, look, I decide that I want to waive that performance bond requirement because I won't actually dupe myself out of my own inheritance. Similarly, your estate is essentially a trust. And for tax purposes, a trust is resident where the trustee resides. So if you appoint an executor, let's say in the United States, and of course here we're assuming that you are a resident Canadian, then your estate will be deemed to be a resident of the United States, and your executor will have to prepare and file the American tax returns as well as the Canadian tax documents. So choosing an executor outside of your jurisdiction of residence can be very costly to both your executor and your estate, so much so that your executor may not be able to post the bond and will be forced to renounce their appointment. Now, in my videos, I talk a lot about the term jurisdiction. And what I mean by jurisdiction is the province, state, or territory where you live. The laws in your jurisdiction will govern your will and the requirements of your executor. So make sure that you check with those laws when deciding who to appoint as your executor. Now, talking about executors generally, you can appoint more than one person to act together to be your joint executor. Now, if you're thinking of appointing your adult children who don't get along to act as co-executors in a last-ditch effort to reunite them, you better think again. Pick joint executors who get along with each other and are on the same page when it comes to handling your estate. If you're providing them with information or talking to them about your wishes, be sure to tell them both the exact same thing. Don't tell one executor you want to have your remains cremated and the other you want to be buried. You can appoint your executor as joint executors, meaning that they have to do everything together. They must both all sign paperwork involved in administering your estate. Or you can appoint them as joint and several. Now, joint and several means that they can both act together, or if one is unable to act, let's say they're in the hospital or on vacation and can't get to the bank to sign documents, then having one executor sign is sufficient in that case. It is important to have a clause in your will that states that should one act alone, they must report to the other of all actions taken, especially those that involve financial matters. It gets a bit hairy when you start appointing more than 2 people to act together. I mean, what happens when there is a stalemate? You need to ensure that you put a clause in your will that accounts for disagreements and how those are decided. Is it a majority rule or unanimous consent? It will be more difficult to get unanimous consent with 3 or more people. Finally, there is an option to appoint what is called a corporate trustee. So a corporate trustee is a business, usually an arm of a bank, that can act as an executor for you. Most, if not all, the banks here in Canada have a branch that offers corporate trustee services, for example, Canada Trust or Scotia Trust. They'll typically charge a much higher fee for acting than an individual would. They will also require a large retainer to be paid before appointing them. And you cannot simply appoint them in your will. You must first meet with them, sign a contract with them, which is also called a retainer. They'll want specific clauses inserted into your will, and they will want to review your will prior to you signing it. They'll also want to hold your original will or know where that original will is being kept. So that's it, guys. Those are the factors you want to consider when choosing who to appoint as your executor. Thanks for watching.